Now, Build One South Africa has launched a petition for the National Register of Sexual Offenders to be made public. The party says the release of this register would ensure accountability and make the public to be more aware of the offenders. To discuss this in detail, I'm now joined by Nobuntu Hlazo-Webster, who is Build One SA's deputy leader. And later, we are expecting and hoping to be joined then by Ntombi Matjila from the National Registrar of Sexual Offenders. Nobuntu, thank you so much for the time. Really appreciate it. I guess we can just start off by really just detailing your notion forward as well. Why it is you'd like this list to, of course, be made public, and, of course, the clear reasonings and how it will aid maybe businesses, of course, South Africans as well, on a daily basis.
No, absolutely. Thank you so much for having us, and thank you for having this important conversation, which actually South Africans have engaged with so extensively. It's been really, really exciting for me to see how engaged South Africans have been, men and women, in this conversation. And so the importance of having the sex offenders register be made public is that we in South Africa have quite a high rate of what we call recidivism, which means that we have perpetrators who are convicted, who are then released, who then become repeat offenders. And so we must be able to find a way that is preventative, because a lot of the interventions when it comes to gender-based violence up until this point have been quite focused on after the fact. You know, what can the NPA do? What can law enforcement do? What should we be doing to make things better, to process the law better, to protect survivors? But we also need to talk about how do we reduce the risk of gender-based violence and femicide even happening to begin with. And I mean, I always make this example of somebody that we all know. Uyinene Mkhwetshane is somebody, it's a name that many people recognize. When you say that name, you can think of the face, that beautiful face all the time. But when you ask who was the perpetrator, many people don't know who that was. And so it becomes important that somebody like him, who actually could technically be released in 12 years and be on the streets again, it becomes important that we are able to protect children, to protect vulnerable people, to protect women from someone who could potentially become a repeat offender. And in this particular case, it is now known that he actually did have a case before that was struck off the roll and now back in court.
32,433 sex offenders are on this document as it currently stands then, Nobuntu. The question maybe the detractors might have with regards to this is, what happens if you aren't a repeat offender and yet your name has been made public and now you ultimately live with that and you're trying to move on?
So the people who are on that register, and what is important to note about it being important that the process, because while we're having this conversation, it's also important to have the conversation about the process of the sex offenders register being compiled in and of itself. It already exists, but we do need to look at what is the process of that, and are we sure that the people that are on that register are categorized as awaiting trial, as convicted? That becomes important. So when it comes to, for instance, the safety of those who are on the register, first of all, there's reference to this kind of thing being a process that takes place. There's some states in the United States where the National Sex Offenders Register is public. First of all, the people who are perpetrators are actually tiered, and what happens is that when they're about to be released, in some instances, communities are made aware that there is this person, they were convicted for such a crime, they are about to be released back into the community. And that information is available on a website. And people talk about protecting the rights or the privacy of perpetrators. But we first of all have to talk about what is in the public interest and how do we protect victims and potential victims. That's a start. Sure. But second is a lot of this information is already in the public domain. So information on public court proceedings and the names of those who are convicted is something you can find online. It's just that it is not easy to find online. Hence, it should be on a register like this. And then thirdly, is to say that the law would have to make it such that Popeye or the Protection of Private Information Act is adhered to. And what Popeye says is that if there is a law that actually has deemed it necessary for information to be public, then that information can be made public. And so this is a legislative process, which we as Build One SA have also taken to Parliament. We have moved a motion for a debate, and we will be bringing a bill. And so if there is legislation that overrides Popeye, which there is precedent for, then that legislation will stand.
Let's talk to the regulatory body responsible for this document then, Nobuntu, and that's Ntombi Matjila, who's from the National Registrar of Sexual Offenders and joins us now. I'm not sure, Ntombi, how much of this conversation you've heard so far. Thank you so much for joining us this afternoon, and hello to you. But the big question mark is certainly around how can we make this list public? Should we be making it public? And if there are any detractions, what are those and why should they stand?
Good afternoon to you, and good afternoon to the viewers, and thanks for inviting us. Unfortunately, I did not get much of the conversation. However, in light of the question that you've just asked, the National Register for Sex Offenders is it's held in a confidential manner. And the basis upon which we held it confidentially is because obviously we protect personal information. And in protecting personal information, again, in the Constitution, we've got a right to privacy, wherein the privacy of an individual must always be protected. If you may recall, during the process when we were dealing with a bill, that subject of making a register public was discussed at length. It was ventilated, and we even had an opinion from Parliament itself, wherein it was held that if we make the register public, for instance, because we are violating one of the provisions of the Bill of Rights, it's not going to stand the constitutional muster. For example, if we are taken to court on the basis that we have willy-nilly disclosed who is actually in the register, we are not going to win should we be taken to court in that regard. So you will also recall that protecting a person's privacy, again, is key on the basis that, our Constitution is still young. And the reason why we did not even go further to say we can disclose who is actually in the register is because, for example, you will see that we feared that if we disclose that a person who is being listed in the register is such and such or is so and so, that person can be attacked. That person, we are not in a mature democracy where, just like in the USA, the way in which you see, they say it is the National Registry for Sex Offenders, and wherein it makes provision for one to disclose. For example, if an offender moves from one area to the other, they must notify the authorities in that place. And then this is where you see that those details of that particular person will be disclosed. Yeah. And lastly, the register itself, even though it is held in a confidential manner, it is available by way of application to anyone that seeks to know whether or not the details of a person are listed in the register. For example, if I want to know whether the details of my neighbor are in the National Register for Sex Offenders, I must apply. And upon application, then we can disclose. However, when you apply to view the details of another person, whether or not they're listed in the register, you must do it in a form of an affidavit, wherein the person that you want to view can actually give you consent to say it's fine, you can go and check whether or not my details do or do not exist in the National Register for Sex Offenders, as long as you are doing that in the interest of a vulnerable person.
Nobuntu, I would imagine that even that last sentiment does not hold for you, because then, you know, anybody you ask can ultimately say, no, actually, I do not give you consent to do that. And ultimately, it takes away from the whole process and understanding and getting to know. What do you think is easier? Where's the middle ground here? Where's finding a way to get to that point? Because even when you speak about categorizing them, for example, these sex offenders, and making that known, it's still about educating South Africans and letting them know and understand how those tiers work, because that can't necessarily assume that because they're awaiting trial that they're necessarily guilty as yet.
Absolutely. I think we have to get to a point where we recognize that we actually have a crisis in this country. We have one of the highest rates of gender-based violence and femicide, and we're in crisis mode. And the way that we approach and address issues in this country is not that of people who are actually in a crisis. Yesterday, I was at Mfuleni police station where a police officer raped a woman that was in custody in a holding cell, as an example. We heard of news last week of a general practitioner who has been convicted twice, has been a repeat offender, continuously going back and serving in a practice as a general practitioner within close proximity to schools and to a community. And so we do have to find a way where we said, which point do we choose the citizens of South Africa? At which point do we choose the women who are being violated and the children who are being violated, and even men who are being violated in this country over perpetrators? Now, when we talk about the access currently that exists, that is certainly not good enough. Currently, in order to access the register, and I'm glad that there was an explanation of the limitations of that. There's an application process, there's a waiting period, which is a minimum of 6 weeks as far as I understand. There's a fee that must be paid. And when we have engaged with various people who've done the application, they've come back and they've told us about the process of waiting. They've told us about what they have had to produce in order to have that information. And like we've heard, you have to be able to, in the instance of an individual, have permission from the person to have that information. Why would anybody who has any plans to be able to offend again give you permission to go and view that they've offended before?
Yeah.
I think that is limited. So to answer your question in terms of what we need to look at, like I said before, POPI permits processing
Sure.
if it complies with an obligation imposed by law, and that's Section 11 of the POPI Act. And so if Parliament amends the Sexual Offenders Act to mandate public disclosure, this can override the privacy concerns over the POPI Act. And that really is about us proving in Parliament, which we intend to do, that it is in the public interest,
Yeah.
especially where public safety is concerned.
Ntombi, just as a final word then, would that win in court or in Parliament, should I say then, by BOSA, for example, would that necessarily change everything for you? Would that change the mandate as well then for the National Register of Sexual Offenders?
Yeah, if it wins, which I doubt it will obviously change the mandate, because, as I've said, we are actually protecting the rights of the perpetrator as well, because that person is a human being.
Yeah.
And we also avoiding, people that are going public just for the sake of it. You will recall that we had a campaign, a Me Too campaign,
Sure.
wherein everyone will just go in there at the whim of it to say, me too, this has happened. But we don't realize what that does to, the livelihood of another person, especially when you vexatiously disclose just for the sake of disclosing.
Yeah.
That is why we're saying that we allow that a person must apply and then prove that the application is made in the interest of a vulnerable person. then we do disclose. Because at the end of the day, what we are avoiding in saying apply to us is to avoid having disclosed information out there wherein it is circulated
Sure.
willy-nilly
Yeah.
to hurt another person's, personal rights and
Yeah.
stuff like that. That is why we have to do it in a controlled manner, because if you want to protect the rights of the vulnerable, like the speaker said, this other particular doctor was operating,
Yes,
having
yes.
been a convicted sex offender. If you have the interest that you want to protect the interest of vulnerable persons, surely we are going to disclose that.
Yeah.
So it's just that people want to make the register just for the sake of making it public,
Yeah.
just to shame and name people who are listed in the National Register for Sex Offenders.
Nobuntu, I'm hoping we'll continue this conversation soon as well, because I think there's a lot to unpack, and there's a lot then that, of course, that you need to set forward as well to Parliament. So we will be keenly watching this as well. Ntombi Matjila from the National Register of Sexual Offenders, thank you so much as well for the explanation, the clear sense of where it is you have to stand on this, and the mandate there is then as well for the National Register of Sexual Offenders. Nobuntu, Hlazo-Webster, your co-founder as well, of course, as Deputy Leader of Build One South Africa, thank you so much for your time. And